There has been a lot of discussion here about peace, the word peace, and what does it mean? Well, I haven't really given much thought to the word peace until recently, because I have 4 sons, and they are dispersed all over the world. And I try to call them as often as possible because they don't call me. I am the one who runs after them and calls them, how are you doing, how is work going, etc., and things like that. And after a while, they tell me, peace, Dad. So I know they want to hang up on me. So for me, peace was always the peace we were talking about here at the court. But now I have learned that peace means also bye-bye. Let me go, I have to run. So this perhaps could be added to the vocabulary or to the definition of peace. I have been at the International Court of Justice for the past 7 years. And I cannot tell you how much I enjoy my work at the International Court of Justice. And whenever I see peace and justice, of course, for me, it means the International Court of Justice. Well, I'm from Somalia. I was born in a small town in the northeastern part of Somalia, but I grew up later in Mogadishu. I went to school in Mogadishu, and I studied at the University of Mogadishu. I came to law by accident because I wanted to study medicine, but there was no faculty of medicine in Mogadishu. There was a faculty of law. So I just joined the faculty of law. I said I might as well study law. And then, of course, as I was finishing my legal studies, I wanted to choose an area in which I should specialize. And when I was studying law, Somalia was involved in territorial conflicts with Ethiopia and Kenya. And I was a little bit interested in how those kind of conflicts should be settled peacefully. And I decided to write my thesis on that, but on the role of the Organization of African Unity on the peaceful settlement of disputes in Africa. And that is how I got into international law. And then I decided to specialize in that area of international law. And luckily for me, I was asked to become a lecturer at the Somali National University. You know, a matter also of circumstances and luck, I should say, because the Somali government was trying to replace the Italian lecturers in various faculties of the university in Mogadishu. So I was the first Somali lecturer in international law at the Somali National University. And I had to learn on the job. At the same time, I had to act as a legal advisor to the Ministry of Foreign Affairs, because the Ministry of Foreign Affairs did not yet have a proper legal department. So I found myself teaching and traveling all over the world, because whenever there was a major conference in which negotiations involved in international law, the ministry would ask me to accompany a delegation. Sometimes with a few hours notice, you have to go to the airport. The president's delegation or the foreign minister's delegation is going to that country, and they require your legal advice. And so it was really a profession that was in high demand at the time in the country, and I decided to embark on that profession at the right time in Somalia. And then when I left the country, I did my PhD in Geneva, and I joined the United Nations, and I just became a professional legal advisor to international organizations, moving from one organization to the other and advising them on intergovernmental issues. And of course, when you have been dealing with international law at the national level and advising the government on international issues. And afterwards, when you have been advising international organizations on intergovernmental issues and trying to help the organization to deal with the relations between states with respect to the mandate of that organization, you are all the time dealing with dispute settlement. You are all the time dealing with the development and interpretation of international law. You are all the time dealing with the prevention of conflict among states. You are trying to promote better relations between states. And therefore, my vocation became peaceful settlement of disputes, better relations between states, the promotion of peace and justice among states. And that is what international law led me into. And I decided at a certain point, because, and this, thirdly, of course, I could say, that it came also by chance, because I was working in UNESCO. I was the legal advisor of UNESCO, and there was a case that was brought to the International Court of Justice by Djibouti, the government of Djibouti, against France. And the government of Djibouti was looking for an African judge who could be appointed by the government, since they did not have a judge on the bench. And a judge ad hoc can be appointed by a government which is involved in a dispute if it does not have its own national on the bench. And so the government of Djibouti asked me if I could accept to become the judge ad hoc of Djibouti in that case. And I accepted. And then I thought maybe I could become a regular judge of the International Court of Justice. I decided to run for the election to the International Court of Justice, and I was elected. And here I am. Now, about the court. As you know, it is a court which actually deals with disputes between states. You have talked a lot about accessibility to the court. Well, the court has a long history. It is not the first court which deals with the settlement of disputes between states. It has a predecessor, which was called the Permanent Court of International Justice. And its predecessor was a court which was extremely careful about the representatives of states and about the states that appeared before it. Why? Because 100 years ago, 150 years ago, international law was not what it is today, number one. Number two, states did not accept to submit themselves to a judicial mechanism for the settlement of their disputes. You are perhaps used, and we are all used, including myself, to a world in which governments appear before courts and subject themselves to a determination of the law and to a decision by 15 or 20 judges. This has not always been the case. 100 years ago, when the major powers of the world met here for the Hague conferences, and the last one was 1907, the only type of dispute settlement institution, apart from, of course, negotiation, mediation, and conciliation, which they could accept was arbitration. They were not yet ready to accept a judicial settlement of disputes. And so there is always some sort of a reluctance on the part of states to submit themselves to an independent judiciary which would decide on the outcome of their disputes and which would decide how their disputes should be settled. So it should not be surprising for you if the accessibility to the court up to now has been a limited accessibility. Because even the institution of intervention, which is an institution that is recognized in the statute of the court, the Permanent Court of Justice, of the Permanent Court of International Justice, and even the International Court of Justice itself, felt for a while that if they brought third states and they allowed third states to come into a case between two states, actually governments may decide not to come before the court anymore because there are these third parties that are allowed by the court just to intervene in their bilateral dispute and to express their views on their bilateral dispute. And so the court avoided for a very, very long time the authorization of third states to intervene in a bilateral dispute between states. And because of the tradition established by the Permanent Court of International Justice, even the International Court of Justice itself paid a lot of respect and treated with a lot of caution the states and the representatives of states that appeared before it. So it is the issue of sovereignty of states which actually led to mainly to the reluctance to submit one's disputes to the International Court of Justice. But we know that the concept of sovereignty has evolved. It's no longer the concept of sovereignty of the 19th century. There is a new concept and a softer type of sovereignty that is applied and used by states in their international relations today. So this has allowed not only the existence of the International Court of Justice, which of course is the principal judicial organ of the United Nations, was the first international court at the international level, but the creation of other courts, of specialized courts at the international level, courts at the regional level on human rights. In the African continent alone, there are 6 regional courts now which deal with regional, sub-regional economic integration issues. So not only has international law changed because the international community has grown, international law has acquired a universal vocation with the adoption of the Charter of the United Nations and the creation of the United Nations itself, you know. And there are now more than 193 states that had never before used an international court to settle their disputes, which are using the International Court of Justice to settle their disputes, to the extent that the court is celebrating today its 70th anniversary, and the cases that were submitted to the court in the last 20 years exceed and are much more than the cases that were submitted to the court during the first 50 years of its existence. So that gives you actually a clear indication of how that reluctance, that unwillingness to submit to third-party adjudication and to subject oneself to an independent judicial mechanism for the settlement of one's disputes has evolved and has softened over the years. So accessibility, and I started all of this by referring to the issue of accessibility. I agree that accessibility should be improved. I think it can be improved, but it will come gradually, as everything about our court has come in the last 70 years. Because when you are steeped in tradition, and when you have to respect and accept the sensitivities that are associated with sovereignty and, of course, with the independence of states and their autonomy or autonomous decision-making at the international level, you have to advance step by step. And I think that is what the court has been trying to do. And one way of improving that accessibility is to allow, for example, other states to file amicus curiae before the court. Not only intervention, but also amicus curiae. And maybe ask international organizations, NGOs, to also submit amicus curiae on certain cases. Because the court is not only tasked with the settlement of disputes. The court is also the major institution at the international level that actually states what is international law, for example, what is customary international law, and develops international law. And the court has played an extremely important role in that respect from its creation in 1946 up to today. International law would not have been today what it is if it was not for the International Court of Justice. And that role, that contribution of the court has to be recognized and acknowledged. When people talk about jurisdiction, that is stating the law, jurisdiction, to say the law, the court has actually been playing an extremely important role in stating the law by interpreting it and developing it. And I can give you a very simple example. Self-determination. Self-determination is a principle of the Charter of the United Nations, but it was not included in the Charter as a right of peoples. So there was no right of peoples to self-determination. And the United Nations General Assembly adopted a resolution in 1960, Resolution 1514, on the right of peoples to self-determination because of the Asian and African group of states which wanted to outlaw, number one, colonization, and number two, put on a legal basis the right of peoples to self-determination. But you know that the resolutions of the United Nations General Assembly are not binding, they are recommendatory. And so, of course, many African countries became independent, many Asian countries became independent after the adoption of that resolution, but there were still a number of countries that remained under colonial suppression and oppression. And when the court was asked in the early 70s to give an advisory opinion first on Namibia, which was annexed illegally by South Africa, and then on Western Sahara, the court took this opportunity to develop the law on self-determination and to say that there is a right of peoples to self-determination and that peoples as such can be bearers of rights and obligations at the international level. And that was really a major development in international law. Because up to then, states were the only subjects of international law, the only entities that were supposed to be bearers of rights and obligations in international law. International organizations were also recognize it as subjects of international law thanks to the jurisprudence of the court itself in an earlier advisory opinion on the United Nations itself. So the court has not only played the role of a peacemaker, it has also contributed to the development of international law, and that, of course, contributed to the realization of justice at the international level by strengthening the rule of law at the international level. Because unless you have clear rules at the international level, you cannot have a rule of law at the international level. We all know what the rule of law is at the domestic level, because we have our civil codes, our penal codes, our common law and jurisprudence in certain countries, but it is more difficult to identify and to codify the law and to say what is the rule of law at the international level. And that is what the court has been doing. And by so doing, it has actually established itself as not only the principal judicial organ of the United Nations, but as it has always been called, as the world court, as the most preeminent court at the international level. I think I will stop here. Thank you very much.